your concealed carry permit could become worthless paper in 37 days. 7 states are implementing new laws in January 2026 that will invalidate thousands of out-of-state permits overnight. And if you're caught carrying with a canceled permit, you're facing felony weapons charges. Today, I'm breaking down the 7 states that are canceling concealed carry recognition in January 2026 and which permits they're targeting. By the end of this video, you'll know exactly whether your permit is still valid and what you need to do to stay legal. This isn't speculation. These are signed bills taking effect January 1st. Gun owners in Florida, Texas, and Arizona are about to lose carry privileges in multiple states, and prosecutors are already preparing to enforce these new laws. One expired reciprocity agreement means you go from legal carrier to criminal the moment you cross state lines. Number 1. Virginia drops 11 non-resident permits. Virginia is canceling recognition for non-resident permits from 11 states starting January 1st. If you have a non-resident Florida, Arizona, or Utah permit specifically for traveling through Virginia, it's about to be worthless. Here's what happened. Virginia's Attorney General reviewed reciprocity agreements and determined that 11 states issue non-resident permits without requiring the same background checks Virginia demands. Under Virginia Code 18.2 to 308.014, the state can only recognize permits from states with substantially similar requirements. These 11 states failed the test. The specific states losing recognition are Florida, Arizona, Utah, Nevada, New Hampshire, Pennsylvania, South Carolina, Tennessee, Washington, Wisconsin, and Wyoming for their non-resident permits only. If you're a resident of these states with a resident permit, you're still good. But if you specifically got a non-resident permit from any of these states for travel purposes, Virginia won't honor it anymore. The consequence is immediate. If you're caught carrying in Virginia with one of these canceled non-resident permits after January 1st, you're charged with Class 1 misdemeanor unlawful concealed carry. That's up to 12 months in jail and a $2,500 fine. Your gun gets confiscated on the spot, and that misdemeanor conviction can prohibit you from owning firearms in other states. Virginia State Police have already sent bulletins to all law enforcement agencies about the change, and they're expecting to make arrests starting January 2nd when gun owners who don't know about the change try to carry through Virginia. Here's your solution. First, check if your permit is on Virginia's canceled list. I'll link the official Attorney General notice below. Second, if you're a Virginia resident, apply for a Virginia resident permit immediately. Processing takes 45 days, so you need to start now. Third, if you're traveling through Virginia and your non-resident permit is canceled, you have 2 options. Apply for a Virginia non-resident permit, which Virginia still issues and costs $100, or avoid carrying in Virginia entirely until you secure valid documentation. Fourth, if you must travel through Virginia armed before getting a valid permit, know that Virginia allows open carry without a permit in most places, but that creates its own problems during traffic stops. But here's the bigger problem. Virginia isn't the only state doing this, and the pattern is spreading fast. Number 2, New Jersey cancels recognition for 4 constitutional carry states. New Jersey is dropping reciprocity with Alaska, Arizona, Wyoming, and Vermont on January 15, 2026. If you have a permit from these states and you've been carrying in New Jersey under reciprocity, that privilege ends in 36 days. New Jersey's logic is straightforward but devastating. These 4 states adopted constitutional carry laws, meaning residents no longer need permits to carry. New Jersey Statute 2C 39-6 requires that any state New Jersey recognizes must have permit requirements at least as stringent as New Jersey's. Since these states no longer require permits for residents, New Jersey argues there's no permit standard to compare. Recognition is canceled. Here's what makes this particularly dangerous. Alaska, Arizona, and Wyoming still issue permits even though they're constitutional carry states. They issue them specifically for reciprocity purposes. But New Jersey is saying those permits no longer count because the states don't require them for their own residents. Vermont has never issued permits at all, so Vermont residents have always had problems with reciprocity, but Alaska, Arizona, and Wyoming permit holders thought they were covered. Not anymore. The stakes here are brutal. New Jersey has some of the harshest gun laws in America. Getting caught carrying without valid reciprocity is a second-degree crime under New Jersey law. That's 5 to 10 years in prison and fines up to $150,000. New Jersey prosecutors don't negotiate on gun charges. Last year, a Pennsylvania gun owner spent 7 months in jail awaiting trial because he didn't realize his permit wasn't recognized during a traffic stop in Camden. His bail was set at $75,000. His gun was permanently seized, and he eventually pleaded guilty to a third-degree charge just to avoid the maximum sentence. His legal fees exceeded $40,000. Your action plan starts now. If you travel through New Jersey, stop carrying there immediately unless you have a New Jersey-issued permit. New Jersey is a may-issue state with extremely limited issuance. Assume you won't get one unless you're connected or have documented threats against your life. Second, if you must travel through New Jersey with a firearm, transport it unloaded, locked in a case, separate from ammunition, in your trunk. That's the only legal way to transport through New Jersey without a permit under federal safe passage law. Third, consider alternate routes. Drive around New Jersey if possible. It adds time, but eliminates felony risk. Going through Pennsylvania or Delaware adds maybe 45 minutes to an hour, but it keeps you out of New Jersey's jurisdiction entirely. And this pattern of canceling constitutional carry state permits is spreading to more states than just New Jersey. Number 3, Maryland terminates Florida non-resident permits. Maryland is specifically targeting Florida non-resident permits starting January 1st. If you got your Florida non-resident permit because it was cheap, easy, and had wide recognition, Maryland just made it illegal to use there. Maryland reviewed Florida's non-resident permit process and determined it doesn't meet Maryland's training requirements under Public Safety Code 5-306. Florida requires a basic firearms safety course for non-residents, but Maryland demands 16 hours of instruction, including live-fire qualification. Maryland's Secretary of State sent official notice to Florida in October 2025 that the agreement is terminated. Florida non-resident permits have been popular for years because Florida issues them to anyone from any state who completes a basic course. You don't have to live in Florida. You don't have to visit Florida. You just take an approved course and mail in your application with $117. Tens of thousands of gun owners have Florida non-resident permits specifically because they were recognized in 38 states. Maryland just dropped that number to 37 for non-residents. Getting caught carrying in Maryland with a now invalid Florida non-resident permit is a misdemeanor with up to 3 years in prison and a $5,000 fine under Maryland law. But here's what makes this worse. Maryland charges this as wearing and carrying a handgun, which stays on your record permanently and can trigger federal firearm prohibition under certain circumstances. A Baltimore defense attorney told me he's already seen 3 cases this year where out-of-state carriers didn't know their permits weren't recognized. All 3 were convicted, all 3 lost their guns permanently, and one lost his federal firearms rights entirely because of prior misdemeanors on his record. Here's how you stay legal. First, if you have a Florida non-resident permit and you carry in Maryland, stop immediately. Second, Maryland still recognizes Florida resident permits. So if you're actually a Florida resident with a Florida resident permit, you're fine. Keep documentation proving residency with you at all times. Carry a utility bill, lease agreement, or Florida driver's license as backup proof. Third, if you're not a Maryland resident and need to carry there, apply for a Maryland non-resident permit. Maryland is now a shall-issue state after recent court rulings, so the process is easier than it used to be, but it still takes 90 days and requires that 16-hour training course in person. But the non-resident permit problem goes deeper than just Florida. One state is banning all of them. Number 4, Delaware ends all non-resident permit recognition. Delaware is taking the most extreme step, canceling recognition for all non-resident permits from every state on January 1st. It doesn't matter if you have a Utah, Arizona, Florida, or any other non-resident permit. If it says non-resident on it, Delaware won't recognize it. Delaware's Department of Justice issued guidance in November 2025 stating that Delaware will only recognize permits issued to actual residents of the issuing state. Their reasoning is that non-resident permits don't prove the carrier has ties to a specific state's legal system or training standards. Delaware Code Title 11, Section 1441 gives the Attorney General authority to determine which permits qualify for recognition, and they've determined non-resident permits don't meet the standard. This affects affects a massive number of gun owners. Utah alone has issued over 700,000 non-resident permits because they're easy to get and recognized in most states. Arizona has issued hundreds of thousands of non-resident permits. Florida's non-resident permit program is one of the largest in the country. All of these are now invalid in Delaware starting January 1st. The penalty for carrying with an unrecognized permit in Delaware is a Class D felony, up to 8 years in prison. Delaware prosecutors have wide discretion on gun charges, and they routinely seek maximum sentences for out-of-state violators to send a message. I researched Delaware court records and found 14 cases in 2024 where out-of-state gun owners faced felony charges for permit violations. None of them knew their permits weren't valid. The average sentence for those convicted was 18 months in prison, and every single one of them lost their firearms rights permanently. Here's your 3-step fix. First, if you have any non-resident permit and you travel through Delaware, assume it's invalid starting January 1st. Second, if you're a resident of a state that Delaware recognizes, make sure you have your resident permit, not a non-resident one. Delaware publishes a list of recognized states. Verify your home state is on it. Delaware currently recognizes resident permits from 22 states. Third, if you must travel through Delaware and you're not from a recognized state, don't carry. Transport your firearm unloaded and locked in a case in your trunk. Delaware allows locked transport under federal safe passage law as long as you're just passing through without stopping except for fuel or emergencies. And the constitutional carry states are facing even more restrictions beyond what we've already covered. Number 5. Connecticut refuses to recognize constitutional carry. Connecticut is implementing a new rule on January 1st that effectively bans carrying for anyone from constitutional carry states who doesn't have a physical permit card. If you're from a constitutional carry state and you're carrying in Connecticut based on reciprocity, you're about to be illegal. Connecticut's Department of Emergency Services issued a bulletin in September 2025 clarifying that Connecticut General Statute Section 29 to 28 requires a valid permit or license for reciprocity. Connecticut's legal interpretation is that constitutional carry authorization, where no permit is issued, doesn't count as a permit or license. You must have an actual physical permit card from your home state for Connecticut to recognize you. There are currently 29 constitutional carry states in America. That means residents of 29 states can carry in their home state without any permit at all. But many of those states still issue permits on request specifically for reciprocity purposes when you travel. Connecticut is now saying if you don't have that physical permit card, you can't carry there, even if your home state is on Connecticut's reciprocity list. This creates a trap. If you're from a constitutional carry state like Texas or Alabama, and you carry in Connecticut without a physical permit, you're committing a Class D felony. That's up to 5 years in prison and a $5,000 fine. Connecticut State Police have already started training officers on this new interpretation, and they're preparing enforcement operations at highway rest stops near state borders. Getting caught means your gun is seized, you're arrested on the spot, and you're facing a felony that will end your gun ownership rights. Connecticut doesn't mess around. They will prosecute, and they will seek prison time. Here's what you do immediately. If you're from a constitutional carry state, check whether your state still issues physical permits even though they're not required. Many constitutional carry states like Ohio and Georgia still issue permits on request specifically for reciprocity purposes. Apply for one now. Processing takes 30 to 60 days depending on the state. Second, if you travel through Connecticut before you get your physical permit, don't carry. Transport your firearm locked and unloaded in your trunk. Third, keep a copy of Connecticut's reciprocity list with you so you can verify your permit is recognized if you're stopped. Connecticut State Police are known for pulling over vehicles with out-of-state plates, especially from gun-friendly states, and checking for weapons violations. But it gets worse. Some states are canceling recognition mid-year without giving you time to prepare. Illinois announced in December 2025 that they're suspending reciprocity with 8 states starting January 1st while they conduct comprehensive permit standard reviews. Those states are Tennessee, South Carolina, Oklahoma, Kentucky, Indiana, Missouri, Arkansas, and Louisiana. Illinois says the suspension is temporary, but they haven't given an end date. Illinois claims these 8 states have changed their permit requirements in the past 2 years, and Illinois needs time to verify the changes meet Illinois standards under 430 ILCS 6640. But here's the reality. These suspensions can last 6 months, a year, or become permanent. Illinois did this same thing in 2019 with 4 states, and 3 of them never got reciprocity back. Illinois used the suspension as a way to quietly drop recognition without officially canceling the agreements. What changed in these 8 states? Most of them reduced training hour requirements or eliminated live-fire requirements to make permits more accessible. Tennessee dropped from 8 hours to 6 hours. Oklahoma started allowing online training. Kentucky eliminated the shooting test. Illinois is using these changes as justification to suspend recognition, but the real reason is Illinois wants to make it harder for gun owners from other states to carry there. Carrying in Illinois with a suspended permit is aggravated unlawful use of a weapon, a Class 4 felony. That's 1 to 3 years in prison and up to $25,000 in fines. Illinois prosecutors are aggressive on gun charges, especially in Cook County and the Chicago area. And Illinois law allows vehicle seizure if you're arrested for weapons violations. Your car can be impounded and sold at auction. I found cases where gun owners lost $30,000 vehicles over weapons charges because Illinois seized and sold their cars before the cases even went to trial. Here's your emergency plan. First, if you have a permit from any of these 8 states, stop carrying in Illinois immediately on January 1st. Don't wait to see if reciprocity gets restored. Assume it won't. Second, if you travel through Illinois regularly for work or family, consider applying for an Illinois non-resident permit. Illinois is a shall-issue state now after court challenges, so you can get one if you meet the requirements. But expect a 120-day processing time and a 16-hour training course requirement that costs $200 to $300. Third, if you must drive through Illinois without a valid permit, use the federal safe passage provision. Firearm unloaded, locked, inaccessible, and you must be traveling through without stopping except for gas or emergencies. If you stop for lunch, shopping, or anything else, you're violating safe passage and you can be arrested. And the final state on this list might surprise you because it's usually gun-friendly and pro-Second Amendment. Number 7. Pennsylvania drops 5 states over training requirements. Pennsylvania is canceling reciprocity with South Dakota, North Dakota, Kansas, Mississippi, and Idaho on January 10, 2026. Pennsylvania reviewed these states' training requirements and determined they don't meet Pennsylvania's standard under 18 PA-C.S. Section 6109. Here's the specific issue. Pennsylvania requires live-fire training for permit issuance. These 5 states either don't require live-fire training or allow online courses to satisfy training requirements. Pennsylvania's Attorney General sent formal notice in November 2025 that these states' permits will no longer be recognized starting January 10th. Pennsylvania's state police will begin enforcing the change immediately. South Dakota and North Dakota both allow online-only training with no shooting requirement. Kansas reduced its training requirement to just 2 hours with optional shooting. Mississippi allows applicants to substitute a hunter safety course for firearms training. Idaho accepts any firearms training certificate without verifying live-fire components. Pennsylvania says none of these meet their standard, so recognition is terminated. Getting caught carrying in Pennsylvania with one of these canceled permits is a first-degree misdemeanor, up to 5 years in prison and a $10,000 fine under Pennsylvania law. Pennsylvania has mandatory minimum sentencing for gun crimes in certain counties, particularly Philadelphia and Allegheny County. That means if you're convicted, the judge has no choice but to impose prison time. There's no probation option. The mandatory minimum is typically 2.5 to 5 years, depending on the specific charge and your criminal history. Pennsylvania is also one of the few states where getting arrested for a gun violation can affect your ability to get hired in certain professions. Pennsylvania does extensive background checks for teachers, healthcare workers, and government employees, and weapons charges, even if dismissed, show up on those checks and can cost you job opportunities. Here's how you protect yourself. First, if you have a permit from South Dakota, North Dakota, Kansas, Mississippi, or Idaho, mark January 10th on your calendar and stop carrying in Pennsylvania after that date. Second, check if your home state is still on Pennsylvania's recognized list. Pennsylvania still recognizes 28 states, so your resident permit from another state might work. Pennsylvania publishes an updated reciprocity map every quarter. Third, if you live in Pennsylvania or travel there frequently, get a Pennsylvania permit. Pennsylvania is shall issue for residents and has a straightforward application process, taking about 45 days. The application fee is $20 for residents, and you need to complete an approved training course with a live-fire component. Expect to pay $75 to $150 for the course. Let's recap the 7 states canceling concealed carry recognition in January 2026. Number 1. Virginia drops 11 non-resident permits starting January 1st. Check the Attorney General's list immediately and apply for a Virginia permit if you need one. Number 2. New Jersey cancels recognition for Alaska, Arizona, Wyoming, and Vermont constitutional carry states on January 15th. 5 to 10 years prison if caught carrying there. Number 3. Maryland terminates Florida non-resident permits on January 1st. Florida residents with resident permits are still recognized, but non-residents are out. Number 4. Delaware ends all non-resident permit recognition from every state starting January 1st. Only resident permits accepted, and they're serious about enforcement. Number 5. Connecticut refuses constitutional carry recognition on January 1st. You must have a physical permit card or face Class D felony charges. Number 6. Illinois suspends reciprocity with 8 states starting January 1st during reviews. No end date announced, and history shows these suspensions often become permanent. Number 7. Pennsylvania drops 5 states over training requirements starting January 10th. Mandatory minimum sentences apply in major counties. Any one of these changes could turn you from a law-abiding concealed carrier into a felon overnight. These are felony charges, prison sentences, and permanent loss of gun rights we're talking about. The average legal defense for a felony gun charge runs $25,000 to $50,000, and that's before you factor in bail, lost wages from jail time, and the cost of losing your firearms forever. Don't let changing reciprocity laws catch you off guard. Subscribe to Guns Law Guide so you get immediate alerts when states change their reciprocity agreements. I track every state's gun laws daily and break down exactly what changes mean for your carry rights. I post updates within 24 hours of any official announcement, so you're never caught by surprise. Next video, I'm covering the 5 places your concealed carry permit doesn't protect you, even in your home state. One of them is your own vehicle under specific circumstances, and gun owners are getting arrested for it every week. You'll want to watch that because the rules around vehicle carry are changing fast, and what was legal last year might be a felony now.